I appreciate the opportunity to be here with you today. JoJo regretted that she could not be here. She had commitment she could not adjust the schedule for. And as is her practice, usually if any group wants for her to speak and she can't do it, she will usually get one of the supervisors or ask if one of the supervisors will do. And of course, I got it. I do appreciate the opportunity to come here and speak with you. Well, let me back up. I've worked with the circuit court in October the 19th, it'll be 34 years. And the first 2.5 years I did microfilming. And then ever since then I've been in the clerk's office. And I'm going to tell you, when I first started working in the clerk's office, I absolutely hated it. I tried every way I could to get out of that office. I went and talked to then presiding Judge Farrell McRae. I got to get out of there. I can't stand it. I was the only man out of about 34 women, employees. It was not fun. I was there to be the whipping boy. I was there to be the gopher, there to do all the crappy stuff that the ladies didn't want to do, like go to the warehouse down on Dolphin Street, go to the basement, all that stuff. But over the time, I had an attitude change. And it dawned on me that I'm not there for my coworkers. I'm there for the lawyers and the people that need assistance. And I'm thankful that along the way there have been people like John Mandeville, the former circuit court, longer than any other person. I actually met him and got to talk with him, and he had his little desk down in the basement, and he would type letters and cut out articles about things in Mobile and send them to his granddaughter. And Mr. Mandeville was a real inspiration to me. And I know as he and I kind of took a liking to one another, and he would say things like, yep, I can say that's a man that knows what the hell he's talking about. And that's just the way Mr. Mandeville was. And then of course there were people like Judge Inch, and such a gentleman, a lot of nuggets that he shared with me. And so, I'm thankful to be where I'm at. I enjoy what I do. I like it. I can't say that there's not moments when I'd like to just take my office furniture and everything in there and just pitch it out the window, or reach through the phone and shake the living daylights out of whoever I'm talking to. But for the most part, I really do love what I'm doing. And, on May the 24th of 1976, two things happened. I turned 19 years of age, and I graduated from Stephen F. Austin High School in Houston, Texas. And in less than 2 weeks, that'll be 41 years. It's hard to believe it's been that long since I was out of high school, and at that time I had no idea that I would be doing what I'm doing now. I had no plan on this. But I believe there's a higher order that directs our steps, and that's why I'm where I'm at, and I enjoy it. I have a good staff, a great boss. I mean, I really love working under JoJo. She doesn't micromanage. She allows the supervisors to work with their experience, and she's there to give us advice. She's there for counsel when we need it. She doesn't try to micromanage. I've got a good staff that works for me. They know what I expect, and I leave them alone as long as they don't mess up two relationships I have that I worked very hard on. And one is with JoJo, and the other was with the circuit judges. If they mess that up, they do anything to interfere, they know that it's they know it's serious business if they create any problems in that regard. So where have we come from? I know that most of you remember the old days, the pre-e-filing days, when you had to hurriedly get something. The lawyer had to have filed right now. It's got to be done, and he brings it to you at 5:15, and the clerk's office closes at 5, and you got to hurriedly get over to the courthouse and get it time stamped because you're facing a deadline for it. And then or you need a copy of something out of the blue file. or needed a copy of the docket sheet. The docket sheet wasn't there because the judge had issued an order and it was down there for the judge to be initialed, or the file wasn't there because there was some motion the judge heard and he took it under submission and he wanted the whole file, and what you needed was in the file, but the clerks couldn't go get it because the judge had taken it under submission. What a mess. Okay. And then, of course, we had to file all the stuff. We had to list it on the case action summary. And it was very time consuming. And I can remember a time in our office, in the clerk's office, where we literally had stacks of documents, pleadings that had to be typed and listed and entered on the docket sheet. Thank goodness we don't have to do that anymore. I don't know how we would survive. But in October the 1st, 2006, the Circuit and District Court of Mobile County, the civil divisions and domestic relations, we went live with e-filing. Now, the first year and a half that we were dealing with it, it was difficult because you had a paper file, you had some documents that had been paper filed, you had some that were e-filed, you had people that wanted to go back and put entries on the docket sheets. We were told, don't put them on the docket sheets. I would take them and scan them and throw them away. My supervisor, there goes Chuck, throwing away those docket sheets. You're not supposed to put any more entries on here, you know. And so we dealt with that. And now we look back, this tool that we struggled with to begin with, and now we wonder, what would we have done without it? You know, so you can file your documents literally 24/7, and the clerk doesn't have to worry about listing it on the docket sheet. It's already in the electronic file. You don't have to worry about the blue file. And if the judge needs something, the clerk doesn't have to run down to the courtroom. The judge can literally pull it up on their laptop on the bench, and they do. It's awesome. It's wonderful. It's made all of our lives so much easier. But there are sometimes problems with it. Sometimes the system, and we're fortunate for this system to have the volume that it goes through, that it works as efficiently as it is. I talk with people literally all over the country, and when I talk about our e-filing system, I tell you what, there's one thing that Alabama is not on the bottom, and it is one of our electronic filing system. I talk to people all over the country, and it is envy. Oh, y'all got this system. It's so much better than this court and that court. Alabama, hey, we're something, you know. But it's because our appellate court, our former Chief Justice, and the administrative office of the courts, they saw further down the road and they saw this need for this e-filing. So this is where we're at now with e-filing. So what I've done is prepare a kind of a little short outline of some things. And these are things, little things that are it's not necessarily you have to do it this way, but these are just some suggestions based on things that I've personally observed, things that coworkers have brought to my attention. And I figure that any time that we can get to a group, whether it's this group or the paralegals, and we can disseminate information to them, then those few that get it, they share it with others, and then all of us are on the same page, and it makes all of our jobs easier. And I feel like this, we're all on the same team. We have different functions, but we're part of the same team. We're part of the justice system of our county and our state. So thank goodness. So let me start off by saying just about everything that you formerly had to paper file can be e-filed now. There are a few exceptions. If you have a district court civil or a small claims appeal, the notice of appeal may not be e-filed. The same thing if you have a court in the circuit court and it's going to the Court of Civil Appeals or the Supreme Court, it may not be e-filed. It cannot. I got into a discussion with an attorney from Birmingham over that issue, and I dug my heels in on that. I told him he tried to e-file his notice of appeal to us So that don't work that way. You got to go through them first. Now, with the IT people and the way they're working on the programmings, I do see a day further down the road where that application will be available, but at this point it is not. That is one thing that does still have to be paper file. Okay, so one other thing, what I've done was just come up with some little things, little pointers for the e-filing. You know, when we went to grammar school, we took painstaking care to learn these things that they taught us, our English language skills, and we learned all these punctuation marks and all these suffixes like Mr. and Mrs. and the periods and the commas and the semicolons. When you're doing e-filing, you really need to drop those. Just drop them, leave them out. And the reason I say that is because when we go into we get a phone call and somebody says, I'm looking for Chuck Lewis. And you have put Lewis, comma, Chuck, Mr. And I go and put Lewis, Chuck. Then the index is not going to pick it up. So it's really better when you're doing that, just drop the punctuation marks. If you're naming a company, like you're preparing a new lawsuit and the company, and you've got your defendant is a company and they're being served in care of the corporation company, don't put corporation company on the same line as the company, because it stays like that unless we happen to go in and change some of that. And I do periodically do that. But with the volume we've got, we just can't do that always. So, there's enough room in the fields where you can abbreviate CO, CT, Corp, and, to North Jackson Street, ST, STE, 605. I do know that's their address. Let's see. Believe it or not, we actually see once in a while somebody with 2000 Interstate Parkway. I'm thinking that address hadn't existed in years. So I don't know where they got it from. They had to have been maybe back before pre-e-filing days. But drop the suffix. This next one, this is the thing that has been the most horrifying to me, is how many times, and just within the last week, we had an order setting a pro-Emmy hearing for pro-Emmy settlement, and went to enter the guardian ad litem's attorney code in the field where it's supposed to, and I look, and there's the first binder's full social security number in there. So I immediately change it 999999, and then I pull up the second one, same thing. Don't do that. It's come into media's attention about how someone used Alicourt to commit crime against people. So, and I understand that they've actually got a mechanism now in place on the ALA file where you can redact information. I'm really glad they've added that. But in case, you forget that, just, please don't put full socials. It will take all nines. And I would recommend that when it comes to an address, don't put the clients. Most people don't do this. But there's always that one or two that, I don't know. Maybe the attorney insisted on it. I don't know. Blame it on the lawyer. Subpoenas. A lot of times, particularly when they're being e-filed, what will happen is on the first line, the filer will put custodian of records. And so if we happen to send it out by certified mail and it comes back detached, which happens not that often, but occasionally we'll get a green card that the envelope will come back, it doesn't have the green card with it, the green card come back, they get torn in the mail sorting machines. And the first line will be custodian of records. If you've got the non-party's name, whether it be Providence Hospital or Mobile Infirmary or USA Medical Center. On the first line, it was much easier because there is actually a subpoena index where otherwise we've got this stack of cards that I've literally got on my desk that have no case, we don't know what they go to. If you happen to e-file, and now officially, non-party subpoenas cannot be e-filed. But in practical application, they can. And as I was explaining, what you have to do in order to e-file a non-party subpoena is you have to attach it to an order to appear subpoena and then just click on their produce records. And there's actually some space in there to put, please, additional information in there. Now, one thing that I had a little concern about is the subpoena form, just like a summons and a lot of other process that is e-filed, the system puts the clerk's electronic signature on it. It does not put it on that civil subpoena. And I've started about a year ago, so let's test this and see. So I tried issuing some just to see if maybe some of the non-parties would balk at it, and I haven't had any problems with it. And I think part of the reason, even though the civil subpoena itself does not have the clerk's signature, that front page is a subpoena, and it does. And we have not had any issues in it. Now, I got a number of phone calls at one time, people saying, I went to e-file this and I got this message in red letters that told me I could be subject to sanctions. And the only sanction that could be possibly is for your subpoena to be quashed. And in order for that to happen, the other side's got to file a motion. They got to file an objection. I haven't seen one yet. Everybody's doing it. It works. So don't rock the boat. but I haven't seen anybody. I personally think it'd be kind of petty. I really don't think there would be much of a grounds for an objection just because it was e-filed. Like I said, that's the kind of thing where if we saw something like that in our office, we would be discussing it. Because anytime it's not a one-man show in the clerk's office. This is not Chuck's show. I have a crew of 10 employees that work with me, and when we see things that are out of the ordinary or they don't quite fit or we can't figure out what it is, we discuss it and we try to figure a way to make it work. And quite often, sometimes the attorney's offices, their staff sometimes is baffled as, hey, I don't know how to do this. And I just quite frankly tell them what we have to do is work. We have to fool the system. You have to work around it and through it and with it. And that's really what it is. It's just using what's available in the most. If you e-file a subpoena, make sure that on that order to appear that it's going to make you put a date on it, and that's the date that you want your documents produced by. Make sure it's at least 15 days out. If we as far as any process goes, the filer has a number of options. You can do sheriff's office, process server, certified mail by attorney's office, certified mail by the clerk's office. All of these are perfectly legitimate. If you choose to do it through the attorney's office, you can use a process server. You can actually e-file the return. It comes in the miscellaneous, we enter it and everything. Now you won't necessarily get, it does a transmittal just like everything. If you do use the traditional green card and you choose to send that back to us, just make sure that somewhere on that green card that it has a case number and like if it's a subpoena, just put SUBP, or if it's a complaint and summons, just CNS. That way we know what it is, because sometimes it's really hard. If I see something like Providence Hospital, well, were they a defendant in this case, or was this a subpoena? So we don't get a lot of those, but that is an option. It is available, and that's the main reason I'm issuing it. If you are filing a document or any kind of anything on a case that was filed prior to July of 2008, and you get some sign of that, like the number doesn't exist, it is probably because it has a point designator, also known as extension. In circuit civil, we use .51 and .52. .52s were condemnations under eminent domain that had been appealed to the circuit court, and that's the only thing they were ever used, .52. .51, it meant a whole bunch of things. Workers' comps, appeals from any administrative appeals from the district and small claims court, a case that required the posting of a bond at the beginning because there was something like a prejudgment writ of siege, or there was a temporary restraining order and a bond was ordered to be filed. All of those would start with a 5-1. And part of the reason I'm mentioning this is since judgments are good for 10 years, we're starting to see a lot of motions to revive the judgments, and although we're in 2017, next year will be 2018, 2008 we dropped the point designators. And the reason we did that because the workers' comp cases were being e-filed, and since they fell in that category of the .51, we said, well, it's too much trouble for us to go back or try to change it. Let's just drop the extensions. So we don't use them anymore. But on those cases, if it was filed prior to July 2008, there's always that possibility as a .51. If you do come across that kind of an issue, you can always try the 5-1. If that still doesn't work, you can always give us a call and we can check. There's sometimes there's some strange things that happen. Always before, you have the option to review stuff. Look over it. Make sure that's what you want to file and it's ready, because once you click submit, there's not a whole lot we can do. Now, if unlike you're entering the information for a summons form and you spell it differently on the summons form than it is spelled in the complaint, there is a way that we can go in and we can correct it and we can generate the summons from our office. But as far as like if you missed a page in your complaint, we can't do anything about it. And the reason that the administrative office of courts has geared it that way is so that there's no appearance that the clerk's office has altered the record, because that's our function. Our whole function is we're the official record keeper and bookkeeper for the court system. That's our whole duty. If you're trying to e-file something, you might want to ask the question, is this something that needs the court to rule on it? If it does, then you want to file it under, is this a response to something? Or is this just something I want in the electronic record? If it needs a ruling, then you want to find a place under the motions. And I realize that there are some of the options just don't work. You try to find one as close a description as possible, but on the motions particularly, there is a generic one called other, and there's two others. There's the first other that has a fee attached. It's up there with the summary judgments and the motions, default judgments. But there's a second other that's a generic. It will let you call it what it is. It will ask for a rule. You can put N/A, and it will take it. It will file it as a motion. We'll process it. All we do is look at it, click it, it goes to the judge. It's that simple. And the judges, they've gotten used to it. If for any, if you click on a motion and it's actually something else than what you clicked on the motion, the judge is not going to look at what you clicked. They're going to look at the body of your pleading. So, I know sometimes I've had people, I clicked it wrong, it's dead such and such. And I even had a pro se individual, I could not convince the man, the defense attorney had filed a motion to dismiss, or in the alternative, for summary judgment. The court just simply treated it as a motion to dismiss under 12B. They never even addressed the issue of summary judgment. And so when this pro se starts discussing me, he says, well, I need to know about such and such and such and such on a summary judgment. I said, the court, but he clicked such and such. I said, the judge doesn't look at what you click. They look at the substance, what you've got in the pleading. That's what they go by, not what you call it, not what we call it. Because we can take paper filed motions, we can scan them in, and they do just like they do electronic files. They'll send a copy to all the parties, and it sends it to the judge also. And I've messed up on them before. I clicked a default judgment that was actually a summary judgment. It's easy to do, and it was too late because I'd already clicked submit. But the judge was not going to call it, this is a default judgment. And he goes, okay, this is summary judgment. And they'll go in and they'll say, this is summary judgment motion. The good thing about civil stuff, it's relatively easy to correct. The key is the sooner that we can catch an error, the better. Okay, I'm now going to talk a little bit about sealed documents. For a long time, sealed documents the attorneys were told you have to paper file them. You have to paper file them. You really don't have to paper file them. One thing you do have to do, you have to have an order to place the document under seal. And we've got one now that everything that's being filed in it is under seal. And because of that, and because of the potential problems, I have actually got more people that have access in our office to the private file. So what we encourage the attorneys to do is when you have a document to be filed under seal, pick up the phone, give us a call and say, I've got this document that's got to be filed under seal. The judge has signed my order and I'm getting ready to file it. Okay, we look for it. As soon as we see it, we take that mouse, we drag it and drop it private file, and nobody except the judge and whoever has access, even the lawyers, don't have access to it. And it's very easy, and through that experience, that's a whole lot easier from us having to scan everything in. The drag and drop method is the easiest, it works, and I thoroughly recommend it. Now, if it's so sensitive that, it can't even be out there for 2 or 3 seconds, you can paper file it, we'll take it. But we really prefer the drag and drop e-file. Okay, what's new? You've probably, if you look on this handout, for lack of a better word, I got the order to appear subpoena. You'll see this sheet from the Mobile County Sheriff's Office. Our sheriff's office has been doing this for a long time. What a lot of people don't realize now is our sheriff's office and our circuit and district court have been working for a long, long time to be able to electronically file process back and forth to eliminate so much paper. So our sheriff's office was actually the pilot site for it. It's the only county that's done this. And we can literally transmit, when we see a complaint, we see a subpoena, we see a garnishment, any process that can be issued from our office, we can review it. If there's anything we need to attach, like a pretrial order, we can attach it. We click a button, it electronically sends it to the sheriff's office. Their computer receives it, prints it out, the deputy serves it, the ladies in the office electronically transmits this page back to us. We get an email that shows us what all has gone, and this literally goes into Alicourt. It sends a notice to all the lawyers, and it posts on just the old system that we use. And the only thing we have to do in the clerk's office is we have to review it. It is really a time saver. For a while it was kind of a pain because, while we were trying to get this system tweaked, we were having to print it and transmit it to make sure everything was flowing through properly. And they do send us an email every day of what all has been transmitted to us, and so we can go through it and we check. Once in a while when they input something, we'll have to go in and it'll show as not served when it was actually served. And this sheet tells you what actually happened. One of the wonderful things about this form, but even before we started the e-transmission, is the sheriff's office actually puts detail on this. It'll show if your summons comes back not found, or your subpoena, it'll show you the date and time, how many times that they've attempted at serving that document. And so there's a lot of information on this one little page. I have noticed that there's one or two other of the sheriff's offices in the state, and I don't remember which ones, but they're starting to use a form similar to this. So I'm thinking that probably it won't be too long before they start the e-transmission also. So it looks different. You're used to seeing the summons form and the bottom filled out by the deputy. It doesn't happen down. This is a return. And if you look at this in Alicourt, it's actually in color. The ones that they said. Now, if we have something for some reason we didn't e-transmit it, it'll be in black and white, but it still is on their official letterhead and has their logo on it. One of the other things that we're working on that has temporarily been paused is electronic transmission of certified mail. We absolutely love it in the circuit court and the district court, because what we could do is we have to print out the documents and we put them in a trifold and have a special envelope, but it saves almost $1.50 per piece by not getting that green card back. But what happens is they actually have a signature place, the post office, and with the address, and it shows the case number, what it was served, and gives a lot of detail there. And it is actually in red and blue on official postal letterhead, and it sends a transmittal to the attorneys just like the e-transmission. Now that system is presently on pause because there were some issues, postal carriers letting individuals other than those designated when we had clearly showed restricted delivery, and the rules do state that when an individual is served, the clerk shall mark it restricted delivery, and we're paying extra for it, but the postal clerks are just letting anybody sign for it. So the last I've heard was about 3 weeks ago. They are working on it. The IT people in Montgomery and the postal officials, they're working on getting this, and hopefully it won't be too long to where we'll have this back on track. Because right now, so much of the process that's coming through the circuit court, civil division, and I'm pretty sure the district court as well, is going by certified mail, and it takes a long time to fill out those green cards and those receipt tags. And just to make sure that we have a point of reference, we scan that green receipt tag in case you have to do a tracer. And so it's very time consuming. So hopefully it won't be too long where this will be implemented. It is good. They are working on it and tweaking, and they didn't scrap it. They just said it's on pause. So I've told my staff, I said, that's a good sign. They said it's paused. They didn't say it was scrapped. You know, pause is good. Let me see. And I think that's about it. Like I said, that's the newest feature is the e-transmission. That is only available as far as the sheriff's stuff in Mobile County. The e-transmission on the certified mail. There are some other counties that are part of the test program. We were fortunate to be part of the test program for the e-filed garnishments. There was only 2 collection firms in the state that were allowed to participate in that. And so we got to be in a good communication with them. And you know, it's a good opportunity because we can look for things that work and let them know this works, and we can look for bugs, things that don't work, and let them know that. So we've been very fortunate because of our relationship with the IT people at the Administrative Office of Courts and the graciousness of our circuit clerk. We've really been able to benefit from being a part of these programs. And that's about all I have to say. If any of you have a question or anything, I'd be more than glad to try to answer it.
I have one quick question. In federal court, your documents are consecutive to things. In state court, the numbers are always wacko. I mean, like the transmission cover sheet has a page, and then the motion or the order has another number. And when I do my own indexes, but anyway, the numbers are just, they don't flow like they do in federal. Is there a reason?
They've actually changed that to where now the documents are all numbered.
I know they're numbered, but anybody else know?
Are they not in order?
Well, it's not that they're not in order, but like the transmission page has got a document number, and then you got your motion, and it's got a number.
Oh, I don't know why they
exhibits have different numbers.
Right.
I mean, they're consecutive, but it's like, why isn't the whole package?
You know, that's something I've noticed, that sometimes when we open it from our end, we'll see the transmittal page first and then the return. And then you'll go to another one and the return page will be first and the transmittal, and I don't know why it does that. I do know that there's a lot of information that flows through the system. You've got 67 counties. You've got circuit clerks, district clerks, judges, and attorneys, and all this information is all going through one big network. And sometimes it's just like a traffic jam. I mean, you know, we sometimes, we can tell when the judges get back off of the bench on Friday when they've had a motion docket, because we won't have any orders, and then 1 o'clock hits and they're back from lunch and just boom, boom, boom. But because there's so much coming through, we might not start seeing those orders till 3:30 or 4 o'clock. It really depends on how much. Now, once in a while, we really do have some real issues in the electronic filing. I always recommend that if AllaFile, AllaCourt, whatever your application you're using, that if you're having any kind of real issue with it, if it's not something that absolutely has to be filed right then, it's better not to take a chance. I always tell my staff, find something else you can work at if it's acting up, because we may have completed something at our end or clicked it completed and it didn't complete. It happens sometimes, and we usually get a blurb from IT letting us know that they're having some sort of a problem, but usually by the time we get that blurb, we're already aware there's a problem. It's pretty obvious, but they're just letting us know they're trying to fix it as quickly as they can. Sometimes it's the system itself, sometimes it's the lines, and just various things, and usually they're short, but once in a while it'll get really contrary. And like I said, if you absolutely have to file it, then you always have the option of paper filing it, because we do have a time clock. We do stamp stuff in, and we still, and so as much as we don't want to have to do that, there are some times when we might be forced to do that. And so it's like Judge Floyd over in Baldwin County said, there's no such thing as an absolutely paperless system, but what we're getting at with this is as close as you can get to it. And for the most part, it's a really good system. It's fairly user-friendly. I do know that the attorney's end of it looks different than ours and the judges, and so sometimes when we're trying to talk you through how to do something, I'm having to visually, okay, where are you at? Okay, what are you doing? Okay, what option do you have now? Try this. Okay, does that work? No. Okay, try that. And it's just, and the only reason I know that is because I printed out the ALA-File user's manual and I've kind of reviewed it. But contrary to what somebody in our office said, I have not had specialized training on ALA-File. One of my employees told somebody, and they said, well, one of your employees said you've had special training. I said, no, I haven't. I don't know where they got that information. I have not. That's it. We'll practice, and a lot of times it's just a matter of common sense. My sense says this is the way you should do it, and I try never take the approach, absolutely this is, especially if I'm not sure. I says, well, I think you could try this and see if it works, and they'll bounce it off the lawyer. Hey, did you try that? Yeah, it worked. Okay, good. All right, I'll remember that for next time then. Any other questions? Okay, well, that's all I've got. I don't want to just stand up here and just take up empty space talking. I appreciate you having me.